Hello, good evening. Okay, let's start our lecture, right? Wow, I think many of the other students are coming. So now tonight I will finish the remaining slides for contract law part 3. Then I will start a new topic, which is the first part of tort law. Okay. So last time I asked you to do a mini homework, right? Remember that? We Before we end, I mean, last time we talked about liquidated damages and unliquidated damages, right? Then I asked you to read at home what are the other possible remedies, right? Just a few slides. So, other than damages, sometimes remedies of the following kinds would be awarded by the court. So those are equitable remedies, and they are usually awarded at the discretion of the court. Discretion meaning the court has the kind of control, right? So which kind of remedies will be awarded, it depends on the situation. So there are basically 3 types: specific performance, injunction, and rescission. So specific performance, to make the party in breach perform what he had agreed to perform. So under the contract, if A and B, there are 2 parties, A agreed to do something but failed to do so, then the specific performance may be awarded to require A to complete the task outstanding. So it will be granted where damages would be an insufficient remedy. So normally damages will be granted, but in case damages are insufficient, then this kind of specific performance will be granted. But note that specific performance is normally not granted in contract for personal service. So for example, there's this dispute between the employer and the employee, and they lost confidence in each other, then it is not good to grant such a specific performance because their relationship has been broken. So, and they lost confidence. Injunction. Basically, there are 2 types. One is prohibitory, the other one is mandatory. So prohibitory is to prohibit one party, the party in breach, from doing or continuing to do something under the contract. So you may refer to this case, the President Warner Bros. The case was that the defendant was an actress and she was ordered not to break her exclusive contract with the plaintiffs. So this is stop the party from doing something or continuing to do something. Prohibitory injunction. How about mandatory injunction? It requires the defendant to carry out a certain act. The previous one is stop from doing, but this one is require that party to do, okay, certain act. So the precedents that you may refer to is this one, Burns Philip Trust Company Limited. The plaintiffs were the trustees, and the trustees specified that they were to have access to and right to inspect the register of shareholders. So this is to carry out a certain act. Okay, so it is a must to do something, mandatory must. Okay, injunction. And the facts in that case were the defendants in breach of the provisions, and then the plaintiff sued, asking for a mandatory injunction. So the plaintiffs were granted mandatory injunction, right? So that's why I said you may refer to this case, Burns Philip Trust, to support this principle, mandatory injunction. Okay, then the third way. Now, here we have 3 items, right? Specific performance, injunction, and then rescission. It's a kind of remedies. To undo the contract, that means to cancel, right? Somewhat like declaring the contract ineffective, no longer effective. Undo, cancel, stop the contract. Put the parties as far as possible back to their pre-contractual position, as if there were no contract. Okay, as if there were no contract. Cancel. Okay, declare the contract not valid anymore. Okay, and then the final term here I mentioned briefly earlier, quantum merit. So meaning what? Again, this term is in fact not in ordinary English. It means that as much as he has earned. So a claim in quantum merit is to award the injured parties the reasonable remuneration. Reasonable. So if the parties say carry out a work which is $100 plus 10% per profit, it should be 100 plus $10. That means with that 10% added. So then if a claim is awarded on a quantum merge basis, then that party should be awarded $110 instead of 100, because 100 could be the cost, while $10, additional $10 is the reasonable profit. So the reasonable remuneration, okay, not just awarding the cost, okay. So both are claims for undetermined amounts, okay. So because what? Because it is not known, it could be unknown at the beginning, but after the work is done, okay, with the cost and the reasonable profit counted together, then we have the undetermined amounts known by that time. So these are the references. Basically, it's more or less the same as those in the previous two parts, for the previous two sections of contract law for FM. So that's why I think I don't need to repeat mentioning all these references. But I just want to emphasize that if you want to read the precedents, the principles in a relatively easy way, I would suggest you reading the final two textbooks. They are more easy to read. Okay, easier. Business law in Hong Kong. Okay, any questions so far? If no, then I would move on to the new topic, tort law. Okay. Okay, tort law for FM. After a brief introduction, I will explain to you tortious liability, and in fact, there are different kinds of liability, and negligence and duty of care, which are the foundations, I would say, in the context of tort law. And also, of course, after explaining duty of care, you also need to know under what situations the duty of care could be breached. So breach of duty of care. Then a very important principle is causation in tort law. Very often, if there's no causation, then the tortious liability may not be established. And then the final part is defense to negligence. So if there is a case in tort, is it possible to reduce the liability? So what sorts of defense one party could be relied on in order to reduce its liability. So this, we will talk about this in the final session. Okay, I would say tort law is really a big area of legal study. If you go to the library and pick randomly a tort law, a textbook on tort law, you'll find that book is quite thick, usually 1 to 2 inches thick. Okay, so it's really a big area. The legal principles involved not straightforward, I must say. If you compare the principles in tort law with those in contract law we have talked about, those in tort law are comparatively less straightforward. But they are very, very important and highly relevant to facility management. That's why we have to study these parts, tort law. So to start with, just a casual question. Can a flat owner install an AC unit outside his flat? Yes. If a contractor hired for installing the units after a fall, dies after a fall, suddenly dropped, fall to the ground, and then dies, is the owner liable? The owner of the air conditioner, owner of this flat. Who is liable? Is the owner liable? The answer to these questions, I would say, is not that straightforward. Right? Some could be yes, some could be no. Sometimes it depends. And the exact questions will always lead to, the answer would lead to, we need to examine the questions in detail and the conditions and the circumstances before we can tell a definite answer. So, and that is why we need to study the law of tort. Now, firstly, we have to understand basically that there are 3 types of tortious liability. Number 1, that liability could be due to what? Intentional torts or intentional torts. So what is intentional? Intentional meaning willful. An act done willfully, intentionally. Okay. And the example is striking someone in a fight. You hit somebody, okay, then that is a kind of intentional tort. Okay, harming the other party, hurting the other party will get injured. Liability for negligence, which is unintentional. Okay, careless, someone like careless, unintentional. For example, slip and fall. Okay, say in toilet. Okay, usually, after washing the floor, where the floor, if not dried completely, is still wet, somebody step on the floor, could slip, right? And fall, and then got hurt. Okay? These kind of accidents are not uncommon. It happens from time to time, right? Then who is responsible? Is it always the case that the property owner should be responsible? It depends. Depends on what? What are the conditions? What conditions would affect the answer? So if you are a facility manager, you need to be clear about this. Because the building, the facility you are managing, say managing a buildings, most of the buildings should have toilets, for example, right? And the toilets need cleaning, okay? Then you need to be aware, confident about the factors, the knowledge in this area. The third type, strict liability. Strict. Responsible for the consequences, even in the absence of fault or criminal intent. So even if you have not done something willfully wrong, but as long as it leads to some injuries, somebody got hurt, it is the kind of strict liability, regardless, even if in the absence of fault, even if you have not done something wrong, as long as there's a consequence, then you, the owner, would need to be responsible. So the example here is Rylance. This is a very famous case, Rylance and Fletcher. A long time ago, a reservoir built by the defendant flooded the plaintiff's mines. Okay. Just a short video, less than 2 minutes.
In this video, we will have a look at the seminal case of Rylance and Fletcher. Plaintiff Fletcher was the occupier of underground mines. Defendants Rylance and Horrocks were the owners of a mill, and they planned to make a reservoir for the purpose of storing water to be used for their mill. Underneath the lands of the defendants, on which the reservoir was to be constructed, there were 5 vertical shafts and some horizontal shafts as well. The defendants constructed the reservoir through an agency which had an engineer and contractor. The engineer and the contractor had not taken reasonable care and caution. When the reservoir was constructed and partially filled with water, it broke through and filled the vertical shafts, and from there the horizontal shafts, flooding the plaintiff's mines, causing considerable damage. The Court of Exchequer was of the opinion that the plaintiff had established no cause of action. On appeal, the Court of Exchequer Chamber decided that there was a cause of action and that the plaintiff was entitled to damages. Mr. Justice Blackburn in the Court of Exchequer Chamber stated thus: "We think that the rule of law is that the person who, for his own purposes, brings on his land and collects and keeps there anything likely to do mischief, if it escapes, must keep it in at his own peril. And if he does not do so, in prima facie answerable for all the damage which is the natural consequence of its escape." Thanks a lot for watching this video.
Okay, in that case, it was a reservoir built by the defendant and eventually flooded the plaintiff's mine next to the reservoir. So, and there are some other examples even nowadays, which are common, like defective products. It could be due to product liability and animal attacks. Like say, when there is a dog and the dog bites somebody, right, it's a kind of tort issue, right? Because the one who got hurt by the dog, right, should have the case in tort law. All right, then in torts, when will such a claim succeed? Right, in order to have a claim in tort to be successful, right, we need to prove several things. Okay, now the first thing is the defendant owes a duty of care to the plaintiff. D owes a duty of care to P. Now this is the first condition. The second condition, the defendant has really breached that duty of care. Right? The third condition is the breach has caused the injury or damage on the plaintiff, of course. And finally, the injury or damage is not remote, must be reasonable, foreseeable, reasonably foreseeable. Okay. So if these 4 conditions are met, then it is possible that the claim will be successful. Right? So now, in any case, in tort, it should be usually a plaintiff suffering injury or damages due to, say, careless act or omission of the defendant. Right? In that case, the defendant, the plaintiff may claim in negligence. So, but he have to prove the following four conditions. Okay. So then, how to prove? What are the considerations that should be taken in deciding whether, say, condition 1 is established, condition 2 is established, and so on. Now, we are going to talk about this one by one, okay? Now, talk about negligence. The seminal case, the very, very original famous case. Still remember this one? Donald Hill versus Stevenson. Have I mentioned this? Anyone have you done any revision? Not yet? You should. If not, you are wise to start doing revision because we have covered several lectures already. And after a few lectures, early next month, you are going to have a test, you know? So I mentioned this. In fact, one of the videos I showed you also mentioned this. And that was a relatively long video. But the video I'm going to show you about this case is relatively short. In that case, it shows negligence. The principles is what is the labor principle. So here are the facts of the case, facts, and the decision. But you can also view the short video, then you can easily understand the key points. Also less than 2 minutes, okay?
Please subscribe and leave a comment below of what other cases you would like me to explain. Have fun. 打这个杯，你说这放生比这样，你的分分了。有牛奶朱古力清脆威化都話精緻對合心，真係更精彩。你啊，真係繽紛樂，一齊叻花。In this video, we'll have a look at Donahue and Stevenson. On the evening of 26 August 1928, Mary Donahue went to a little cafe in Paisley, Scotland, with her friend. The friend ordered a pear and ice for herself and a Scotsman ice cream float, a mix of ice cream and ginger beer for Donahue. The owner of the cafe brought her a tumbler of ice cream and poured ginger beer on it from a brown and opaque bottle labeled E. Stevenson, Glenlane, Paisley. Donahue drank some of the ice cream float. Donahue's friend poured the remaining ginger beer into the tumbler, and a decomposed snail also floated out of the bottle. Donahue claimed that she felt ill from the sight and pain of abdominal pain. She received emergency treatment and subsequently diagnosed with severe gastroenteritis and shock. The case of Donahue and Stevenson establishes three major legal principles. Number one, it established that negligence is a tort, as the defendant has not purchased the ginger beer.
There's also a key point here. So there's no contract between the parties, which I will further explain this to you. But the first principle here is negligence is a tort. Okay. The second point, I will explain it to you.
The ginger beer manufacturer. Two, the manufacturer has a duty of care to the final consumer. And finally, number three, the neighbor principle, the rule that you must love thy neighbor, which becomes in law at 12 million. Don't stop at you. Make you have this without them be part of the law.
Okay. Now, the key principles. Let's have a quick recap. In fact, the video already highlighted the key things to you. Now, the case was that between Donald-Hill and Stevenson. The plaintiff, Donald-Hill, okay, drank a bottle of ginger beer, but that beer was not bought by Donald-Hill, but bought by her friend, okay, from a retail shop. That's why there was no contract between Donald-Hill and the shop, but there was a contract between her friend and the shop. Okay, so the bottle, which was opaque like this one, okay, which you can't see through, and while the plaintiff, Donald-Hill, drank some of it, right, drank some of the content, it was found that there was a death snail. Okay, and the plaintiff became ill after noting the death snail, shock, basically, right? Shock, and then became ill. Then the plaintiff, Donald, claimed damages from the manufacturer, the party manufacturing that bottle of ginger beer. Okay. And the plaintiff could not sue the retailer because what? Because, as I said, there was no contract between Donald-Hill and the retailer. Okay. Because what? The ginger beer was bought by her friend, not Donald-Hill herself. But the decision was that there are several principles established from this seminal case. Number one, the manufacturer was liable. The manufacturer owed a duty of care to the ultimate consumer. In fact, when the manufacturer produced ginger beer in the factory, the manufacturer could hardly know exactly who will consume the ginger beer. But the manufacturer should take care of the final consumer. The rule that you are to love your neighbor, take care. Okay? You have to foresee who will consume your product. Okay? Say like you are owning a building, you're operating a toilet. You have to take care of people using the toilet. Right? Avoid them from slipping and falling onto the ground. Avoid them from getting hurt. Same principle. So you must take reasonable care to avoid acts or omissions which you can reasonably foresee. Okay? Persons who are so closely and directly affected, you must take care of them. So to help your understanding, I prepare a diagram, a sketch, which I hope it can help you understand the picture, the overall picture in this case, easily. Now, in reading cases, you are recommended to do something similar to this one, like what I've just shown you. This is a relationship diagram. In fact, for your seminar project, one of the tasks for the project is to draw a relationship diagram. Okay, this is one example. Donald-Hill is here. Donald-Hill's friend bought the beer from the retailer, right? There's a contract between Donald-Hill's friend and the retailer. And then what? Donald-Hill's friends gave her the beer. Donald-Hill drank the beer, found the death snail, became ill, right? And there was no contract between Donald-Hill and the manufacturer. Manufacturer sold the beer to retailer, retailer sold the beer to a friend. Okay. So, but there was contract here, but there was no contract between Donald-Hill and the manufacturer. So, in case of something wrong, what Donald-Hill can get compensated? Could get compensated through tort, sue in tort, not in contract, because there was no contract, right? So could only sue in torts. Right? Understand? Okay. So that is the labor principle, okay, established in the above case. So it implies that duty of care is established when there is what? Foreseeability of harm. The harm is foreseeable. And another principle is proximity. Close enough. Okay? Closeness, not too remote. And it should be fair, just, and reasonable. Here we have three further conditions, okay, in order to establish duty of care. So here I have the slides explaining each of these conditions, but could also give you a better idea by viewing a short video. About negligence, duty of care.
Hello everyone and welcome to the first of our video tutorials on negligence. In today's video we'll be looking at the first element in proving negligence, duty of care. Just a reminder then that in order to prove the defendant liable in negligence, the claimant has to prove firstly there was a duty of care, secondly there was a breach of that duty, and thirdly that this resulted in damage. But today we're going to focus solely on how
the first one, duty of care.
Tort Stevenson is the first case to look at here, because this case established the model law of negligence and it established the neighbour principle. I'm not going to go over the facts again with you here. There's a little video link that you can look at to remind yourself of this if you go onto my PowerPoint. But for now, we're just going to focus on the principle from Tort Stevenson. So, Document Stevenson was massively important because it was a case that came up with an original precedent that manufacturers of products have a duty to the ultimate consumers of their products. But this case is also important, particularly for duty of care, because it established the neighbour principle for deciding when a person will be under duty. In this case, Lord Atkin famously said, the rule that you are to love your neighbour becomes in law you must not injure your neighbour. On the lawyer's question, who is my neighbour, receives a restrictive reply. You must take reasonable care to avoid acts or omissions which you can reasonably foresee will be likely to injure your neighbour. Who then in law is my neighbour? The answer seems to be persons who are so closely and directly affected by my act that I ought reasonably to have them in contemplation as being so affected when I am directed my mind to the acts or omissions which are called in question. Luckily, you don't have to memorise the neighbour principle that I've just read out, but the reason that I've read it out to you is to show you that the neighbour principle is basically saying that you owe a duty of care to anyone who is close to you and that you can reasonably foresee is likely to be injured by your acts or omissions. But you could hear from what Lord Atkin said that the neighbour principle is quite waffly and not very clear. So in the next case of Caparo and Dickman, the judges took the opportunity to give a much clearer test for establishing when a duty of care would be owed. So in Caparo and Dickman, the neighbour test or the neighbour principle was replaced by a three-part test for establishing a duty of care.
This case is more recent compared to the previous case, 1990. So the three parts test is basically more or less same as the points are included in the PowerPoint slide.
So was the damage or harm reasonably foreseeable? Was there sufficient proximity, meaning closeness, between the claimant and the defendant? And is it fair, just, and reasonable to impose a duty? What we need to do now is look at some cases that help to illustrate each of these stages. So we're going to start by looking at how do we work out if the damage or harm was reasonably foreseeable. This case, unreasonably foreseeable, is a case of Kent and Griffiths. And this is where the claimant was suffering an asthma attack, and an ambulance took 30 minutes to arrive. And the principle from this case was that it was reasonably foreseeable that a claimant would suffer some harm of the failure of the ambulance service to arrive in a reasonable amount of time. In Jolene Sutton, you can see that the council had some land where there'd been an old boat abandoned, and the council knew about it and knew it was all dilapidated, but they left it there. And some 14-year-old children were playing on the boat, and one of the boys actually propped the boat up and was underneath it, pretending to be a mechanic or something. And unfortunately, the boat fell on it, and he was left paralysed. And the issue here was this reasonably foreseeable? And the council were trying to argue that it wasn't reasonably foreseeable. How could they possibly predict that someone would lift a boat up, climb underneath it, and be...
This case shows that for children, we need to take special care of them, right? Because what, say if an adult, by looking at the conditions of these broken ship, the adult may not play around with this ship. But for children, right, they are relatively naive, right? So we have to take special attention, care to.
That it was reasonably foreseeable that some injury would occur if children played on or around it. And so the defence had staggered negligent. So they were sort of saying there that you didn't have to foresee the precise type of harm, but you just had to foresee that some injury would occur. Into Griffiths and Jolene Sutton there, both of these cases, the court decided that the harm was reasonably foreseeable. So it's nice to contrast those cases with a case where there was a different outcome, where it was held not to be reasonably foreseeable. And this is the case of Thornhill and Young. And in this situation, we had a motorcyclist who was speeding, and he was involved in a crash and killed. And Mrs. Thornhill was about 8 months pregnant at the time, and she was 50 yards away from the accident. She heard it, but she didn't see any of it. But afterwards, she did see some of the motorcyclists who was on the road. She went into shock, and her baby was born stillborn. And she was trying to claim for the stillbirth of her baby against the motorcyclist's estate. In other words, that his negligence had resulted in the loss of her baby.
Okay, now the key point here is the lady only heard the accident, not really saw the accident. Okay, so the court held that the motorcyclist did not owe her a duty of care because what, it was not reasonably foreseeable. It's too remote, okay, that she would be affected by his negligent driving because what, she only heard the accident, the crash, but not really saw the accident. Okay.
Affected because she didn't actually see the accident.
Okay, now then I think I can show you the link. So that when you have time, you can take a look at this video. Okay, because we didn't have sufficient time to show you the whole video now. But I already highlighted the key points to you. So it's the link here. Okay, you can view the video later. Here, let's go back. Okay. Okay. Now the three conditions: foreseeability, proximity, and the final one, fair, just, or reasonable, or not. So foreseeability, Already mentioned in the video, the Ball Hill and Young case. Remember, I've just talked about. So the lady heard the accident, the noise created by the collision, but not really saw the accident. And the lady was a pregnant woman and got nervous shock. Then she sued. It was held that the plaintiff, that means the pregnant woman, failed to establish that the defendant owed her a duty of care. Because what? Because the speed of the car didn't endanger her and unable to see how he could reasonably anticipate that accident. So that means it fails to fulfill this principle, foreseeability. Okay. So it was held that the plaintiff was not within the line of vision. She didn't really see the accident. She was not so placed that there was any reasonable likelihood of her being affected. So her claim failed. Okay. Failed because of the failure to establish foreseeability. All right, then the second factor or condition is proximity. Whether the two parties, the plaintiff and defendant, are close enough, have direct relationship. If not close enough, that means no proximity, then no duty of care. Okay, as illustrated in this case, which involved the hospital, okay, Chung Ki Leung case. So what happened in that case? It's about, again, a pregnant woman deliver a baby. So the deceased was admitted to the ward of Port Hoi Hospital. Deceased, okay, this party, okay, administrators of the estate of Lau Siu Chun. So she died as a result of complications arising from childbirth. Complications occurred. And the hospital was aided by the government. You know, many of our hospitals in Hong Kong got financial aid funding from the government, right? Aided by the government. But not actually operated, I would say operated by the government, aided by the government. However, the government had no control over the operation like hiring and firing of hospital staff. Okay, not directly controlled by the government on hiring and firing matters. An issue was whether the government owed a common law duty of care to the lady died, the deceased. It was held that government provide financial assistance, but it was immaterial to the deceased who funded the hospital, okay, to which she was admitted. So there was maybe closeness between the lady and the hospital, but it's not close enough between the lady and the government because we have three layers, right? Government, hospital, lady, right? Okay. So the deceased close relationship, as I said, deceased, the lady, and the hospital, okay? Close relationship. But no proximity between the deceased and the government because there's one layer between the hospital, okay? All right, the final one, fairness, justice, and reasonableness. The Donoghue Stevenson case, referring to the same case. As I said, no remedy could be sought in contract because there was no contract, right, between Donoghue and the manufacturer. It would not be fair just if there is no remedy in tort, right? If we only have contracts, then Donoghue could not get any compensation. So that's why it would not be fair and just. But how to determination of fairness, justice, and reasonableness, not perfectly definitive. Right? So if you are interested, you may further read this case, White and Jones. But here I can highlight the key facts of this case to you. In that case, the defendants were solicitors. And they were instructed by P, the plaintiff, to draw up a will. You know, before somebody died, he may like to instruct his solicitor to form a will, say after his death, how to dispatch these amounts. This amount is the £9,000 at that time in the old days. Solicitor delayed in carrying out the father's instructions. That means delay in drawing up the will. After a month, that father asked the solicitors whether the will has been drawn up. Again, the solicitors' delay failed to do so. Then what? The plaintiff sued the solicitors. It was held that it was fair, just, and reasonable, okay, that the defendants should be liable. That means the solicitors. Because what? The solicitors were in breach of his professional duties to draw up the will within a reasonable time. Okay. So it was fair, just, and reasonable. So that is exactly the principle here. Fairness, justice, and reasonableness. Okay, now I would like to stop here, slide 22. Then after the short break, I will continue explaining the context to you. All right, but I would like to highlight one thing. Have you received my announcement today saying the in-class activity? I found some of the cases searched, identified by some of the groups are not in compliance with the criteria. Okay, the length, how many words, the pages, right? There was one group already submitted the case. Which group? You. Okay. So you should pay attention to the requirements. Okay. So please refer to the requirements, right, criteria, and then try to find a case. Okay. All right. So let's take a short break. I would resume the lecture very soon.